All right, and we are live. So first of all, to everybody watching, thank you so much for joining. My name is Justin Bachman. I am a reporter with WZZM 13 on your side. We have been on your side for a long time discussing the UIA, the Unemployment Insurance Agency, and some frustrations that people have been having for quite a while as the pandemic made a lot of things change. A lot of people who never thought or never knew that they would need to rely on unemployment that found themselves in positions of needing those benefits. And as time went on, a system got stressed, some frustrations took place, and then we saw a lot of things kind of fall through the cracks and some changes need to be made. So we have been following this story for quite a long time. We've been getting questions for a very long time about different parts of unemployment benefits, ways that it is impacting our viewers throughout the state of Michigan. We wanted to bring in some experts to be able to help answer those questions. We've got things that we've taken directly from viewer submission, but before we get to those, I want to introduce the people who are going to be answering those questions and helping us get a sense of the knowledge that we need to know to handle these situations of unemployment and what we might be dealing with. So joining us tonight are Tony Paris and Lisa Ruby. Tony Paris is the lead attorney with Maurice and Jane Sugar Law Center for Economic and Social Justice in Detroit. Lisa Ruby is the public benefits attorney with the Michigan Poverty Law Program. I will let them introduce themselves to give you more of a sense of their credentials. Lisa, let's start with you.
Okay. Hello, everyone, and thanks, Justin. Thanks for having me. It's a pleasure to be here. I am the public benefits attorney at the Michigan Poverty Law Program. We are the state support office for legal services offices in Michigan. So you might be more familiar with legal services. They provide help with civil matters to low-income households in Michigan. And seeing as I'm the public benefits attorney, the unemployment benefits have fallen underneath my umbrella. So happy to be here and to impart whatever knowledge and guidance I can to you.
Thanks, everybody, for having me. I'm Tony Paris, the lead attorney at the Sugar Law Center. We're a workers' rights nonprofit law center in Detroit, Michigan that serves throughout the state, anybody who has unemployment insurance issues. Unfortunately, now I think it's up to our 13th year that we've been battling Michigan's unemployment insurance system, not just in this most recent pandemic, problems that have arose, but historically, Michigan's unemployment insurance system has been particularly bad beginning in late 2013. In addition to the hearings and the protests that we assist you all with, we've also have multiple large-scale federal and state class action lawsuits that we're involved in to try to get the agency to change its ways. And so we not only kind of help you get your unemployment insurance benefit issues cleared up, but we try to remind the state that they need to change or else it's going to be another decade of pain.
I can't hear Justin.
That was because I was muted. We love virtual technology.
I'm just glad it was you and not me. Sorry.
Absolutely. So let's jump into one of the viewer questions that we've got. I've got my notes here in front of me of some of these things that have been sent in over the past week, but it's issues that people have been dealing with for months on end. This first person has been dealing with it for at least 4 months. They say, for them, it's a long story, but the bottom line is that the UIA set up a phone hearing with an administrative law judge after over a year of filing appeals. The phone hearing was in September and ruled in our viewers' favor. They got a letter with a decision date in September of 2021 and a letter that was sent to the UIA saying that they do not owe any restitution, but they still keep getting monthly statements saying that they need to make restitution payments or their taxes could get garnished. They tried calling, they've been getting letters, and they've been told that it has not been filed yet and their file hasn't been processed yet. Rather, they said they're worried about this wrecking their credit or their tax refund getting garnished. The question overall is, when will this get processed? After 4 months, it's gotten very frustrating. And then talk a little bit, if you could, about the possibility of that wage garnishment as well.
So I'll start, and then, Tony, of course, feel free to jump in. The first thing I noticed with this question, and as attorneys, we always have more questions when they're questions, when someone asks a question. So my first thought was, this person said that they have been filing appeals plural. And the way that the unemployment system works is our clients they get multiple determinations. And so they can get multiple letters. Actually, one of your questions coming up talks about people getting letters one after the other, week after week, sometimes multiple ones on the same day. And they pertain to different cases that are within their MyWAM account. So MyWAM is the unemployment portal. And so typically what we would do, not every advocate does this, is get permission and with the client, maybe with a screen share, go into their MyWAM account to try to make sure that what they think is happening is what's actually happening. So if this person had filed multiple appeals, they could have multiple cases going on. And so they had an administrative hearing for a particular claim, or it sounds like an allegation of an overpayment, and they got a positive decision on that, which is great. We don't know, based on this, whether or not they have other claims, other cases that are within the MyWAM. They could have multiple things happening from multiple periods of time. They've cleared up one of those claims, which is great. And even if it is just one, it does take some time, unfortunately, between the ALJ decision, which is an administrative law judge for people who don't know. They're in a separate department from the unemployment agency. So that department or that agency has to give the notification over to the unemployment agency and say, hey, we ruled in this person's favor. This overpayment needs to go away, or this person was always eligible. There never was an overpayment. That takes time to get processed. And one of the problems is that it's not reflected in their MyWAM account. So even though they've gotten a good decision in their view, like, great, I was eligible, I don't have an overpayment, they're waiting for it to drop off of their MyWAM because they go into their account and it still says they owe a bunch of money, and it takes a long time for that actually to drop off of their account. And I know the question was, when will this get processed? I'm so sick of it. Welcome to our world. I mean, I do have empathy for the person. I don't want to make light of it, but a lot of these questions, the running theme through them is that things are taking a really long time.
Just in addition to that multiple issue thing, and which is absolutely true, the individual needs to check their determination status tab on their MyWAM account to make sure that the issue closed level 3 in their favor for whatever issue it might have been. Identity verification, quit, fired, you name it, is not the only pending issue, right? Many times we have judges rule in folks' favor. Judges don't necessarily know that the agency has treating every different issue that can arise in some of these claims as a separate case number that needs to also be appealed up the chain to the judge as well. That's the most common thing, and Lisa hit a nail on the head. The agency has a severe problem of processing administrative law judges' decisions. Policies changed not too long ago where the agency now they say, well, we can't pay you out or get rid of your restitution, because what if we want to appeal? So it's at least 30 days because the agency's policy is, well, if we got rid of your restitution or paid you and then we appealed and won, you'd have to owe that again, and that could be a problem. So we're just not going to process it, right? In addition to that, this is wild stuff, right? How about this one? If the person is not only being asked for restitution, which it looks like that's what they said, but is also maybe owed weeks, very common, we call them hybrid claims at sugar law. Not only are you owed some money that it was held up because of the protest, you were certifying you were still unemployed, but you're being asked to pay back what you got. Well, in order for it to not only have your restitution go away and your account to be right because you're owed some money, it has to go to these even higher supervisors. Maybe there's only one, Wizard of Oz, behind a curtain, that all of a sudden says, oh Lord, this person might be owed 5-10 grand in benefits. Only so-and-so up there can even approve of any of that, and they're behind now hundreds of folks. So you got to wait even longer. The calling almost does nothing. The calling is nearly a waste of time completely. luckily, not too long ago, the agency opened up in-person meetings with the various offices. I know many of you may be in the Grand Rapids or Lansing area. Heard those aren't the best offices for claims examiners to be there. But down here in the Detroit area, we're always wondering, maybe there's humans with a harder brain up here in the Utica office, where at least my last 15 folks have gone there quickly, promptly, and been paid out. The Detroit office, not that bad, but not that good, because unfortunately, the culture of whether they want to pay you out or delay you, or whether they're looking at your winning hearing and say, yeah, but there's another issue we could flag. It's prominent in the agency, and it obviously needs to stop, but these are some things that you can do in the meantime. The question with the credit, right? We were told in a civil deposition where the person was under oath that unemployment insurance debts aren't reported to credit agencies. Although we're hoping that that's true, one thing we do know in poverty law is that debts spiral other debts, right? And so if it ends up resulting in a bankruptcy that you want to throw your unemployment restitution in, or you can't make other payments because you're freaked out, or your tax return gets taken, and so you're owed money, obviously that will severely affect your credit, let alone your personal life often. But very often we used to see tax returns being garnished, and it's obviously tax return now. I have to put this woman on the spot because I really want to make, I was in a hearing today, and a Kathy Gallagher, who worked for the state of Michigan as a lead claims examiner, assured me while she was under oath with the judge, and her supervisor is a woman named Teresa Burns, right? Everybody out there should remember these folks' names very, very carefully. Kathy Gallagher assured me that if there's a pending appeal or a decision in the person's favor, there will be no garnishment or collection activity. Let's hope we can believe them. It's election season, everybody. Let's hope we can believe them, because right now we are severely worried that all the folks in tax time are going to have their tax returns garnished for a debt that they do not owe. So double check your MyWAM, make sure everything's been protested, try to get to a hearing level if it hasn't been, make an in-person appointment to try to speed it up. As lawyers, we don't necessarily have a magic wand to speed up the agency internally, right? But it's always the best thing to do to stay on them, not on the phone, obviously, but go in to make one of those appointments, which there's a link right there available on the Michigan site.
Hopefully I'm unmuted now. One thing that I do want to add, we're talking about these backups and these backlogs. We did reach out to the UIA to get answers to these questions, and they did not give us specific answers. But one thing that they said is that they are doing more claim processing each day, saying that they're up to 6,400 daily contacts with claimants in this past week. So it does look like they're trying, but there are a lot of people, much like our question askers, who are still frustrated and who are still worried. I also have heard from the UIA that if there is a pending claim, they don't have to worry about wage garnishing or tax return garnishing or anything like that.
Yeah,
I think we should move. Oh, go ahead.
Well, I just had a quick comment, and Tony, it's great to hear you say that, because that's what we would expect. One of the problems that our clients are running into, though, is people who have filed a late appeal or a late protest. So the actual protest itself, the first layer of appeal, isn't technically pending because it was filed late. And so the person has filed it late and then filed a claim of good cause to say, well, I filed it late because of one of the reasons. And especially during the pandemic, it was filed late because people were confused, inundated with letters. They were making phone calls. They were calling the agency. They weren't necessarily getting great information. And so one of our concerns is for those individuals who haven't even gotten in the line yet. They're waiting to hear whether or not their good cause will be granted for filing late. If it is granted, great, then it'll be like they filed timely, and then there'll be no garnishment that's happening. But we have people who are waiting, I don't know, 6 months or more, just to find out whether or not the agency is going to decide they've met that good cause criteria. And if they're denied that, that's something that they can appeal. But in the meantime, what's going to happen to their taxes? I mean, are they going to be garnished? Because technically, from a procedural standpoint, have they actually filed an appeal? Because they're still waiting to find out if it's going to be found to be timely.
Absolutely correct. Also, all you viewers out there, no mail protest. We were told at one point the agency was 6 months behind processing mail. So you get a denial and you mail in the protest and say, I disagree with this. It might be on a truck to Nantucket for all we know. Let me tell you, fax is even hit or miss. MyWAM, although it's very frustrating and needs to be revamped, is still the best way to make sure that you've gotten protests on every issue and to make sure that the agency sees them and is able to process them quickly. I was told by an attorney general one time under Dana Nessel, hey, Tony, don't submit any protests that say any and all issues. And I was like, well, that's what you do. It's what we always did, what you always have to do, because we don't know without getting into their MyWAM what all the issues are. Any and all means any and all. There's a dictionary where it means everything. Like, the system can't relate to that. Any and all blanket protest. They gotta go in, oh, you quit, protest, write the same thing. Oh, not able to work, quick, protest, write the same thing. Cut and pasting the same thing to make sure that they all get processed. Then, as we all saw in the pandemic, you have multiple claim numbers, multiple case numbers generated from just extensions. So they, our wonderful folks watching at home, think I only have one case number. It's the most recent one that I've been dealing with. No, they can go back all these years of your early parts of the pandemic claim, and there could be letters hiding in there that you have to protest or appeal. And that's really the thing, because Lisa's absolutely right. You miss one of those 30 days, even though God bless this Kathy Gallagher, technically then, after 30 days, you don't have a pending timely appeal, and the state can bring down the garnishment hammer.
So Tony, let me ask you a question, because I wasn't sure if I heard you. I did hear you say don't mail it in. And I'm just wondering, to file the protest, better to, I mean, I'm thinking you click it right on MyWAM, hit file a protest, not through the messages, not through faxing, not through snail mail, everything through MyWAM. Is that, do you think that's the best way to go?
If possible. Fax is second best. The tricky part about fax is if you're protesting a first decision called a determination, it's a separate fax number, 517 number.
Wow.
Than
Okay.
it is if you're protesting a appeal, which is your second protest. That's a 616 number. Now, of course, if you read the document thoroughly, that's all in the very fine print towards the end. If you need the fax, because you're either locked out of MyWAM or don't use a computer or otherwise can't understand it. But remember, MyWAM, although frustrating, is still the quickest way to get it into the agency. And many folks do the chat function or do the message function and say, I want to protest it. But all the chat comes up from the MyWAM point of view on the other side is like a little love letter, Facebook. I miss you, baby doll, or whatever it is. No,
Heart
it doesn't
emoji.
get protest. It doesn't get processed as an actual protest, as it would when you go into the determination status tab of your MyWAM and click the file protest button right there along the line of the negative issue.
So it seems like, looking through the questions that we have laid out, we've actually addressed a lot of the stuff in the second person's concerns as well, of what do I do about filing my income taxes? Do I try and contact an adjudicator by the phone, or wait till I receive a letter and send something back? Tony, it seems like what you're saying, like you just repeated, MyWAM or bust is the best way to do it. Fax if you need. I want to move on to question 3, and there might not be an answer directly to this. This is somebody saying they've been waiting on a claim since December. They haven't been able to work and earn an income since the beginning of the year. They're on temporary shutdown and will be returning to work April of 2022. They're wondering who, if anybody, is it possible to get in touch with to try and expedite this process? Is there a person in the agency? Is there a course of legal action to try and make sure that your case does get heard and does get processed? Or is it simply that waiting game?
Again, just to go back to my previous thing, you don't have totally a magic wand to speed it up internally. I often tell folks that I get involved when the hearing is scheduled. I can always look at their MyWAM, look at the paperwork, tell them what might still need to be protested. But as far as speeding up what is now in process or pending adjudication or in progress, I have found recently the best things to move that along are in-person appointments at the various in-office locations. Or a later question deals with, I went to Michigan Works and asked them questions. That's not an agency office, right? And a lot of the folks on the phone were hired in some firestorm of get a lot of contractors in just to process claims. They had no experience in unemployment insurance law. They had no experience in claims adjudication. They were just supposed to delay, deny, and appease everybody. I find in the actual offices, these are often claims examiners, some higher level ones who can process these things quicker. And I find some of my folks have good luck at moving things along. And I always say, hey, even if you're thinking about denying me, claims examiner, do it. Then I can at least get a hearing. The horrible part is the limbo. Waiting is the hardest part, you know, but just go ahead and deny me and I'll get Tony Paris and we'll go into a hearing together. But oftentimes the agencies using this, you know, we're taking them in the order that they've been, you know, heard. The only other trick that I think Lisa and I might, you know, advise people, oftentimes state representatives or state senators get a legislative liaison. And if you contact your state office, you know, whoever your legislator is, sometimes they have a way to kind of push things through. It's hit or miss still, but it's another option to try while you're waiting.
So, and I wanted to add a couple things onto that as far as trying to go outside the mechanisms in place. Contact the governor, contact the attorney general. We encourage our clients who we can't really help because they're just waiting. Contact people, let them know. We want to know everybody's stories. I think that they're aware of it, but I think that it's important for both sides to know what's happening. And Justin, I don't know if you're going to get back to question 2. I just had some comments about it.
Absolutely.
So
yeah, to introduce it, this is actually a person who we interviewed for our air today. They have been told that they have to pay back $10,000, even though they sent in their 1099 and it was approved time and time again. Their benefits got increased because of a calculation the UIA made, and now they're being told that they have to pay that back despite having those letters of approval and those submitted documents. So there's a number of questions that we laid out. Lisa, if you want to go ahead and just kind of pick and choose for which you wanted to address.
Well, the main thing I wanted to address, it's hard to know whether or not this person was actually overpaid. Like, we haven't seen the calculations. We don't know what the numbers, what it was, what it got increased to. But what I just wanted to emphasize, because in their questions where it says, here are the questions, it says, how long will I have to wait until I find out if I receive a waiver? I just want to make sure that people understand that there's a difference between protesting the overpayment itself, protesting the finding of ineligibility. So they're saying you weren't eligible, and typically it comes months to years down the road. You were never eligible. We have clients who say, oh, you're never eligible going back to March 2020. So someone can file a protest, meaning they're appealing that decision because they're saying, no, I was eligible, or yes, I should have gotten all of this money. But it's different from requesting a waiver. And so they're not going to decide a request for waiver if there's a protest pending. I don't think this is good law, but so they won't even look at the waiver while the protest is pending. And so for this person who submitted this question, it's unclear what they actually filed. So if they filed a protest and they're waiting for it to go through fact-finding adjudication, they can request an administrative hearing if they lose all the way down the road. But if they file the request for waiver, it's not going to be looked at until the protest is done if they've gone through the whole appeal process. Then they can look at the request for waiver. And if the request for waiver is denied, that is also something that they can appeal. So I just want to make sure they point out to people that they know what they're protesting. They're asking for a waiver. They might be using the things interchangeably, but they actually know what they're talking about. Language is really important, especially like Tony was saying, reading the fine print. They need to know what they're doing if they're not speaking to an attorney or another advocate, to make sure that they're protecting themselves.
I think that's a very important thing to point out, because before this waiver process became what it was in the past couple of weeks with the help from the DOL, a lot of people were simply told by UIA employees or the people that they called in, file a protest. And whether or not that was the correct course of action now people are back in that holding pattern of that protest cycle, even though a waiver might be what they actually need. Is there a way to cancel a protest and apply for a waiver that won't slow the process down?
I wouldn't, yeah, I agree with mostly with Lisa, and you're absolutely right, Justin, that waiver has gotten a lot of more talk in the news as of late. I would never cancel a pending protest for a waiver. Remember, a waiver is almost like not exactly, but it's like a backup plan. It's an argument that we make that says, listen, even if you were eventually ever shown to have not been eligible to get these benefits, you can do these waiver issues. The agency's made these mistakes, which they've admitted. If your income level is low, but if you win your protest issue, none of that matters because you're supposed to get your restitution away. And so, although I agree with Lisa, it's not good law that the state's position is, well, you got to keep your protest going, and then we won't look at your waiver. I still sometimes have people fill out the waiver when they're in a period of low income relatively, because it looks back on 6 months. And then, yes, if it takes the agency even longer to process that because they're looking at the underlying protest, fine. Maybe we'll win that issue and the waiver can eventually be ignored. But in the meantime, the protest or appeal is still their most important thing. Folks out there should not let the waiver language, will the state house waive it? Will Governor Whitmer waive it? Who will it apply to? Who the federal guidelines are out, 40 pages of very confusing language. Should we just hope that politicians eventually waive it? No, we should process the protest up the chain so we get to a potential hearing or an adjudicator that's forced to look at the facts and deal with it that way first. And then, of course, if it just doesn't go in your favor, or even oftentimes during the hearings themselves on regular protests, you're allowed to kind of hint or argue waiver-ish arguments that the agency made these errors. They approved folks countless times, 4, 5, 6 times before flipping their own decision. They waited over a year. This is another common thing that getting a hearing is really important on, because the judges and the appeals commission above the judges is saying, listen, agency, you took over a year. You had no additional information. You can't reverse your own self after a year under the law. No restitution is owed. Of course, that needs to go to a hearing or be processed as a protest before we get those good languages in the decisions. But those things are more encouraging than whether Governor Whitmer or anybody else can, with a fell swoop of the pen, just get rid of all waiver restitution.
Yeah, and just to talk a little bit more about waivers, because I know, Justin, you mentioned this has been in the news the past couple of weeks. There was the letter that went out last June with the 4 questions, and everyone seems to be aware of that. The governor said, oh, we're not going to make people pay this money back. So close to 700,000 people got these letters, and just that group of letters. Maybe half of those people, their overpayments were waived. We don't know what happened to the other half. So now we have this new guidance from the Department of Labor that talks about it's giving states broad waiver powers. And I believe that Michigan could waive probably, I don't want to say every pool overpayment that's, not actual fraud, but probably could come close to it because they're pretty generous. But the state has to ask for those. So just because the Department of Labor has said to all the states, hey, go for this, we can do this, the state has to proactively come up with language, and then they have to determine whether or not someone actually has an overpayment. So they have to still process the claims that are out there, because they have to decide someone, look, I said they should allege an overpayment, say, okay, we think that you have an overpayment, and then whether or not they're going to waive it. So there's a bunch of steps that are going to be in place before whatever action is going to be taken under the DOL, the Department of Labor's, their new guidance, where claimants are actually going to benefit from it. So it's a great start. It makes me optimistic. I hope that is what's going to happen, but it's not going to be, I think Tony used the magic wand. There's no magic wand. It's just a lot of bureaucratic muck, and hopefully we'll keep going through it and come out the other side, and claimants will get what we think is the outcome that we believe they should get, but it's not going to happen anytime soon.
And the other thing that the individual who asked question 2 should know, because I see the word misrepresentation there. under our laws, you can't have your waiver ever processed before, during, or after a protest if the allegation of fraud or misrepresentation has been found against the claimant. It's in our statute. So a lot of folks who are looking to get their claims waived back, during the previous scandal, were not able to even get it processed after being led down the wild goose chase of a waiver because there was a fraud flag on the file. Now, I would encourage this individual, and I saw in one of the later questions, this fraud is being used. One of the good things about our successful federal lawsuits that went down in 2015 and one still pending from 2017, they actually were required to not auto adjudicate fraud, right? So no more robo fraud. A human has to be involved. Unfortunately, many of your viewers out there are seeing the word misrepresentation in the upper corner of a document or issue type on MyWAM, and they're freaking out. And they're writing misrepresentation or fraud, and they can't believe they think they're being charged with it. I don't think I've seen one, right, in over 2 years. Because if you read the language carefully on those decisions, it says, and this is the brainiacs behind the curtain, you are not ineligible under 62B, which is the fraud provision. So we're not ineligible. Our teachers in English class taught us in middle school not to use double negative. The agency says we never had middle school language. So they wrote that right in there. And my folks are freaked out. And they protest that sometimes when it's in their favor. And it keeps the misrepresentation issue alive. And the judges are like, why was this protested? It's in your client's favor. And I was like, well, better safe than sorry. Because in addition to that double negative language, there's a sentence right after that, usually, that restitution is established under 62A. Now, restitution in the unemployment world isn't considered fraud or misrepresentation. That would add a penalty, right, for you deliberately getting benefits you weren't entitled to. Restitution is just a word that means you got benefits, you got to pay them back the same amount, right? Interest maybe, but you'll see in the penalty column of a lot of bills, zeros, 0, 0, 0, zeros. If this was real misrepresentation or real fraud, it wouldn't say 0. It would be 1.5 times the amount that they were paid they owe back as a penalty. So I give the agency some credit for taking that auto robotic fraud off and making, even though it still gives them issue type, it doesn't actually charge that person. And a lot of folks out there are misled because of that confusing language.
While we're talking about fraud, I want to move on to that last question, the one that talks about fraud, just so we can kind of keep on that. This person was collecting benefits between April and October of 2020. Since then, their benefits have been cut off, even though they say that they qualify. They say that their claim was an error and that their case was sent to the fraud department. They've sent in documentation validating their eligibility for benefits, and they're still waiting on their case to be reviewed for what they say has been 16 months later. The two questions that they have and that I have in reading this is there a timeline for that case to get resolved, which we've talked about at length? And then the other thing is, what are their rights and what ways do they have to protect themselves if they are being accused of fraud?
So normally with fraud, they use fraud departments. Maybe they heard that somewhere through the agency. How it was described to us in the federal lawsuit was the system is programmed where whenever there's an overpayment for any reason, regular restitution, the algorithm of the computer has to go to that misrepresentation issue by how it's programmed, just to see whether that was an intentional overpayment, right? So that's why folks are seeing that as a very common issue that still pops up, even if it's technically in their favor. So hopefully they're not actually being charged with fraud. Hopefully, if they were being investigated for fraud, they would actually get a phone call or a meeting or something with a human being, which is what we assume is being required by the folks, inside of the agency. And just to protect themselves beyond just the basic protest and appeal that we've already done, to know that the timeline is kind of legally ambiguous, right? The state isn't allowed to write a new determination on an issue it's a 3-year statute of limitation, right? Obviously, if there's already been a decision, our argument is that it's 1 year or less, right, to process it. And then the big case that we look at for all of this is a United States Supreme Court case called JAVA, J-A-V-A. But unfortunately, like all lawyer language, it's extremely vague. It just says that benefits need to be payable when due, and that really they're not allowed to be keeping these things going indefinitely, not paying people out or otherwise processing a claim. So those are the underlying, I guess, deadlines that they might face.
Tony, thank you very much for weighing in on the fraud side of things. I know there's a lot that goes into every single part of this. A lot of the frustration that we're seeing, and I'm going to jump on to the fourth viewer question that we got here, is someone saying that a lot of the same things that we've been hearing, that this is a person that's a seasonal worker, they get unemployment for parts of the year, they say 4 months, they've never had an issue that they're having right now. The last day that they worked was 12/3, and they haven't been able to get any of their unemployment, but they are still getting letters every week saying that he hasn't registered to work by a given date, filing for unemployment on December 6th, going on to MI Works, registering for work on the 8th, submitting. So we have this whole timeline of proving or saying how they have done the registration that it seems they would need to. And the frustrating part being the live chats through MyWAM, talking to someone on the phone, talking to my work staff. Every time they're getting different answers from people. The question here that I want to make sure that people answer is there a way to try and get a consistent answer and to get the correct answer when seeking out information?
So the short answer is no. I mean, you're going to talk to different people, and unfortunately, as Tony talked about earlier, they hired thousands of people to answer the phones at the unemployment agency. They weren't trained, they weren't state employees, but they were a human, and people wanted to talk to a human. But people are given inconsistent information, and they're giving wrong information. I had a client who was told they had to get a medical waiver because they could only work part-time to prove that they could only work part-time from 2019, from before the pandemic. And this was from someone who was answering the phone. So people are not getting consistent information from person to person. I just want to make sure that I emphasize, make sure people understand, whoever's listening, make sure you're filing the stuff you need to file, because, and I know that these are just anecdotal stories and people are telling you and you're not getting to the nuts and bolts, but when I hear about people going on live chat and making phone calls and talking to someone at the agency and they're submitting additional information, I want to know if they've actually had a denial, and I want to make sure that they filed a timely protest, because I think that there's so much information that is sent to claimants, multiple letters, multiple conversations. People are they're confused, they're overwhelmed, especially this person, he's not getting paid. And so they don't necessarily think, like, put on the attorney hat that says, oh, there's a deadline, I have to make sure that I file a protest on this, because they're talking to different people. They expect it to be cleared up at some point by submitting whatever it is they're submitting. They went back to Michigan Works. Just make sure that they're filing the protest in a timely fashion to protect themselves, and then they can comply with whatever these other requests are. We still want them to give the verification they're supposed to give, even if it's asked for multiple times. We hear that regularly. Who knows where it goes? It's lost in the system. Maybe they didn't upload it in the correct manner. Maybe they faxed it in, or they put it through MyWAM. They sent it in a letter. We don't know where it ended up, so it's very possible that nobody laid eyeballs on it. So just to do it again. And then they also want to look to see if they're able to certify. I don't know what's happening with this particular claimant, but he wants to look in MyWAM and see if he is able to certify, because sometimes, again, as Tony mentioned, people aren't going on to MyWAM. They don't have access to MyWAM. They don't have a computer. They're going through their watch. They might be limited English speakers. They may live somewhere where their internet is not great. And so they can only go through the phone system and they can't get on a computer. And so there is a question about whether or not they have the ability to certify each week, like attest to that they're not working and sign their little affirmation. If they can do that, they should continue to do it, because sometimes some of these hiccups, like everything else, it's just a cluster. Everything's all clogged up in the funnel. And if they've gone in, they have the ability to certify, they do that. And then, it's unclogged and everything gets cleared up and then they're approved, then they're going to be able to get paid because they've actually been certifying all along. But there are times when there's no ability to certify, but they should definitely check to see if that's a possibility for them.
Lisa's absolutely right. I would imagine my mother or father, or somebody getting a denial or not knowing and just starting to get on the phone.
Mm-hmm.
You know, instead of going through, signing on MyWM, making sure the password's right and get on, clicking on view all claims, going claim by claim, determination status, is it against me, protest it. It's like, I'm gonna try to get the nice person on the phone. No, it ain't gonna happen, right? We have a former intern a summer or two ago who's one of the batch that was hired, and the stuff that these folks were trained on was just completely wrong in a triage type of situation. The other one I had today was really unfortunate because she was being accused of protesting late. And during our hearing, the judge was like, well, we first have to do a whole good cause issue. You were 4 months late. And she's like, I really don't think I was or would have been. And then, of course, it was in her message. It was timely, but it was in her MyWM, send the agency a message, right? That's not protested by the agency as a protest or appeal. Of course, she's probably going to still win that issue after going through this headache, but it's something that, you know, just send a message or hoping to chat is just not the same as going through those main channels. And we were told by multiple folks going back before the pandemic, one of the main problems with Michigan's system is the ways that information are received by claimants. The right hand and the left hand don't really communicate or tell each other what's going on. Hard copy mail gets scanned in late and goes to a separate department. It gets mailed out from another department. The chats go into one portal of the other side of what they're seeing. The protests go into another portal. You need the experienced claims examiner usually to make sense of it all. And so to make sure that the protests or appeals go through and, you know, as much as they can, I mean, I can't tell you, I know most of the folks I help have issues with having an easy internet phone access with MyWM, no matter what. But once they're in my office and we go through it together, we usually solve the mystery. And so that's one of the most important things for people to keep in mind. I need it again.
Am I back?
Yes.
Awesome. Did it again. Spectacular. You'd think that I don't do this for a living. I mess that up every time I'm on Zoom. But looking at the questions that we have left, they're very similar, as most of these are, to all of the things we've gotten of somebody being told that they need to pay back $26,000. They've called 4 times this week and gotten 4 different responses. They want to know why communication is so inconsistent. And it seems like what you're talking about, of that hiring frenzy of trying to get by. And question 6 is similar, of how long will this take to process? And so we've talked about those a lot. Both of you, a question in closing. There's a lot of frustration and there is a lot of concern for people in the scenarios that they're in, and they're all their own little bit of different, but they're all very similar in the way that they're struggling to find a way through this and trudge through all of the different ways to understand all of the UIA and what they need to do. The question I want to ask in closing is twofold. What do you think is the best way that people can address their issues? And then the second part is, what can the UIA do moving forward to make it better for Michiganders and easier to submit claims for unemployment to be a better system?
So number one, the one thing of what claimants out there can do, I think if you painted it with a broad brush, is just not to give up. Back, especially during the early scandals, folks get overwhelmed. You see a $30,000 debt, you can't get a hold of anybody, you can't understand it. You start to think, maybe I just do owe it. Maybe I just gotta put it in the drawer and hope that they never take it from me. It's literally the only thing you can do wrong, right? Going to the agencies, talking with Lisa, talking with myself, doing whatever you can to get those protests and appeals there, no matter how uncomfortable it is the most important thing to do. is not to give up. Another thing I have to say, the common theme, no matter who I've talked to, the hundreds of thousands of people, is I'm never doing this again. Oh Lord, if I would have known. Well, it's easy for me to say, but that really, really, really is a mistake as well. This was a public benefit that was originally made partially with Maurice Sugar, who our founder, to be liberally construed to aid the injured worker between periods. Don't let any modern politicians or computer algorithms change that you are all entitled to this money. Don't let them try to convince you that there's a stigma around unemployment insurance. Every other industrialized nation provides guaranteed income for folks during times like this. And they've marked you and branded you and done all of those things. Talk to your neighbors, call us, get on Facebook chats, talk to your elected officials. Remember, this is a specific thing that happened. The reason why they had to do a mass hiring, the reason they put in this broke system that we've been complaining about is because they laid off 200 to 300 claims examiners 5 to 10 years ago. Humans who have done this their whole job, who could write up claims, talk to you on the phone, meet with you in person sometimes to save money, to try to save money, like try to save Flint money. It never does, it never did. But they're worried that the politicians are going to be able to say unemployment filings are down, not because they've created good jobs or because it's because they've broken a system and nobody wants to use benefits that can make the difference between their day-to-day bills, their day-to-day job, their children's lives, you name it. Don't give up. Don't take no for an answer. Vote these people out when you watch them destroy the system. The system needs an utter revamp. And we've said that from the beginning, and we've seen finally, coming up on the 10-year anniversary of it, I had a meeting last week where they're going to try to figure out how to make the forms better or more user-friendly. Well, we've had federal lawsuits over that. And the agency's position through the Attorney General under both administrations is maybe a few force us to, but I think it's fine. We're not going to change it midstream, or, they could have read it better. They could have done whatever. These are the servants of the people. They work for you, everybody. Remember that. You have the power. Keep communicating together. Don't take no for an answer, and expose these people. Expose them when they decide to make decisions that hurt the working people of the state of Michigan.
I would add to the best approach for claimants. I mean, Tony's absolutely right. Don't give up. Try not to panic. Don't pay something that you don't actually owe. Like, we are seeing clients who have timely protests. So there's no question they've protested timely, but they're getting bills from the unemployment agency, and they're not actually subject to garnishment at this point. There's been no final determination on their claim. They've timely protested it, but they get the bills and the agency keeps sending them out. And so our clients are afraid. And so they're making payments on them. Our clients will contact us and say, well, I paid on this anyways because they just sent me a bill because they're nervous. And the website that they send people to for overpayments, one of the things on it, it says what can happen to you if you've been overpaid. You can have your wages garnished. You can have your tax refund garnished. And then one of the things says refer to the prosecutor for felony prosecution. So that's terrifying, and that's up on the state's webpage. I talked to a gentleman who told me that he was afraid of losing his house, his car. He was going to go to prison. He was going to move out of state. People have had monetary repercussions. They've had, foreclosures, bankruptcy, suicide. Suicide is a real thing. Threatened suicide, actual suicide from the financial stress of not having income. So there's a lot of sad stories out there. So as much as people can seek help, both legal, non-legal help. And if you contact an attorney, because when I do these interviews, or if I'm in the paper, and I know this happens to Tony as well, we get a lot of contacts after that. So if someone wants to send me an email, it's great if they actually send screenshots. They can redact them if they're afraid of giving me their personal information, because I'm overwhelmed. My coworkers are overwhelmed. Tony and his coworkers are overwhelmed. So if we get that first email and someone says, this is what's happening, and here, this is the notice I got, and this is what it says on my MyWAM, it's more likely that they're going to get, I would say more likely to get a response potentially, but actually a responsive response, because if you can respond with an email because you have all this great information, then you might shoot one off if you can think about it off the top of your head. The part two of your question, which I just had to chuckle, what can the unemployment agency do to make things better? And I'm thinking, man, to Tony's point that this has been going on for a decade, when Director Gray was the director of the unemployment agency, he loved to say, I'm trying to fly an airplane and repair it at the same time. And I think that was a good analogy. And sometimes I feel like when we talk to the agency now, we're saying, the airplane's crashed, it's on the ground, we need a new airplane. And they're saying, the airplane's fine. Look it over there, the airplane's great, we're ready to take it up into space. So getting on the same page has been so politicized between the administration and who's in the House and the Senate. We have elections coming up in the fall. People need to think about that, contacting their legislators. The forms issue that Tony was just talking about, there's a nonprofit called Sevilla. They help redo the forms for the Department of Health and Human Services here in Michigan. It was amazing what they did with the application. The forms now are just like, you're not disqualified. So it says misrepresentation, but in the body it says there was no misrepresentation, we're just kidding. Make the forms so they're able to be read. Being the director of the unemployment agency is not an easy job. There are reasons for that. I don't know all the reasons, I can guess, but they've had 11 directors in 10 years. And so the culture within the agency needs to change. The forms need to be simplified. The communication, some of it is the culture. I think of the technology, money. Give them more money so they can blow up Midas and redo MyWAM. And if you've ever gone on the portal for Health and Human Services, which is called My Bridges, it's great. It's so user-friendly. Boom, boom, boom. You can find exactly what you want. You go on MyWAM and it's just 2 hours later, maybe you'll have an idea of what's going on. And that's for an attorney. For regular people to do that, it's just too much. These things could be simplified and having real human beings look at the notices that people are getting, because they'll say that we don't have the robo fraud going on anymore and that eyeballs are checking these things, but we know that some of these things are purely robotic. Some of these forms that are going out to clients, because they've already prevailed at an administrative hearing, they've won, and then they're still getting a notice saying that they're subject to collection. So if a human being had looked at that and checked it, hopefully that form would not have gone out, but yet they're still being issued by the agency. And I'll stop to see what Tony has to say about how the agency can reform itself.
I absolutely agree with that. It was encouraging to see the forms being changed, the MyWAM user friendliness, everything from what looks to be a link that isn't a link, and then what isn't a link, doesn't look to be a link to click on. I've struggled with it, for years, and I really do feel that this experiment is failed, right? The idea that we're gonna digitize or automate the human decisions on constitutional implicated public benefits, it failed, right? There's a reason why Michigan was one of the first ones that tried to robotize fraud. Like a computer can somehow get into a specific intent of somebody, and it's failed. And the experiment, whatever side of the political spectrum you're all on or out there, if you are a fiscal conservative, this has failed, right? And it was supposed to save money and do whatever, it failed. And if you're somebody who believes that working people should have easy access to unemployment in between jobs, it's failed. So both sides, it's failed. Unfortunately, the battle seems to be, do we quit a horse in midstream, / the private company or companies involved in programming this that work with the state own the intellectual property for it. We got to stop that experiment as well. Privatizing some type of government function in every other state, government function traditionally, government function by its nature, but the idea that we're going to do some government by spreadsheet business, calling people customers when they're trying to do whatever, this is not Applebee's, people. This is people's livelihood and their rights. I don't want the director of some type of online gambling thing to come into Michigan's thing and say, hey, we can do it really quick with these bells and whistles that way. and then go into our state legislature and then use the revolving door to get that contract and back and forth. All of that's failed. Okay, let's just move on from it and go back to actual person writing out an unemployment insurance decision that can be protested or appealed promptly with proper staffing and proper understanding and training of the law.
Well, Tony, Lisa, I want to thank you both so much for joining us, for giving your insight and giving your expertise. There are still a lot of people who will have questions, and there are resources listed, phone numbers, links in the description of the YouTube video that will live in perpetuity, and also the version that will live on our website as well. So hopefully people are able to find resources. I guess the thing that I'm taking from today is be patient, be persistent, and do not give up. So thank you both so much for your time. We will continue to be on your side here at 13 to make sure we are getting questions answered, and we will continue to cover this story because it is far from over. Thank you all.
Thank you.
Thank
all.
you.